Good evening, everybody. My name is Bhavin Shah, and I will be moderating today's engaging discussion. In the early days of building Presolv360, I attended a seminar on mediation. Imagine a room filled with curious people, all there for the mediation session. The speaker started talking about Bhatna and Vatna, and everyone was just soaking it in. Just then, a funny thing happened. The person sitting next to me was confused and inquired with me that isn't this about meditation, and had absolutely no clue that it was a seminar on mediation. Everyone shared a good laugh, but that moment got me thinking. Fast forward to today, that funny confusion turned into a deep realization. I saw that mediation is much like meditation. It's a gentle conversation that helps resolve disagreements, bringing peace, much like meditation does bring calm to our minds. The shift from seeing mediation as just a legal tool to understanding its power in fixing conflicts feels like the calm journey one experiences in meditation. Now, as we delve into the Mediation Act 2023, the amusing memory from that training session resonates with the essence of mediation, a harmonious bridge over turbulent waters, now strengthened by the pillars of law, inviting us all towards amicable resolutions. The Mediation Act 2023 finally becoming law signifies statutory recognition being given to online mediation and also streamlining the mediation process in our country. To help us understand the implication of the Act better, our panel consists of 4 individuals from different veins of law who bring a variety of perspectives into the conversation. In order to infuse today's dialogue with perspective, insight, and knowledge, we have Justice Kannan Krishnamoorthy, who is a former judge of the Punjab and Haryana High Court, and also a trained mediator from Harvard Law School. Next, we have Ms. Chitra Narayan, who is not only a lawyer, but also an accredited mediator with more than 20 years of experience. She is also the author of Mediation, Policy and Practice, and is a visiting faculty at Sai University in Chennai. We also have with us Mr. J Jawad, who is a senior mediator with the TNMCC and is a senior trainer with MCPC Supreme Court of India. Mr. Jawad is also the president of Mediators India, which is a registered Pan-India Association of Mediators. Finally, we have a practicing advocate and an international arbitrator and mediator, empaneled with many reputed organizations, Mr. Sagar Kulkarni. He has 13 years of experience in the field of mediation and arbitration and runs his own law practice at Lexwith, Pune. Presolv360 is committed to fostering inclusivity, and in line with this objective, we have Dr. Renuka Rameshan, who is a sign language interpreter and the president of the Association of Sign Language Interpreters of India. A warm welcome to all the panelists and the audience. If time permits, we will be taking questions at the end. Request the audience to put them in the Q&A box. To begin the discussion for today, my first question is for Justice Kannan. The Act formally introduces the term online mediation and mediation service provider. While online mediation is self-explanatory, a mediation service provider, in simple words, would mean an institution or platform that helps facilitate the conduct of mediation proceedings so that the mediator and the parties can focus on the dispute and its resolution, while the administrative and procedural tasks can be left to the mediation service provider. Sir, in this context, would you agree that formalizing the concept of online mediation and mediation service provider would enhance the experience of the users of mediation? And how, in your opinion, can this lead to wider adoption of mediation and a higher success rate of resolution?
Thanks, Bhavin, for getting me over here. And I'll run into your question directly and confront it without having to say other things. It's an interesting categorization that you're making. The mediators and parties will mind disputes and establish the processes. And service providers will look into administrative and procedural tasks. Put together, the users of mediation, which would mean all the parties as well as the mediators, would experience an enhanced comfort level. That, I suppose, is the assumption. You'll notice the preamble of the Mediation Act it enumerates some related subjects, one juxtaposed to another. What it says is an act to promote and facilitate mediation, especially institutional mediation. That comes as the first expression. Among other things, what you have to enforcement of mediated settlement agreements, provide for body of registration of mediators, encourage community mediation, and make online mediation. So therefore, you have the idea to promote and facilitate an institutional mediation as the first thing emerging. An institutional mediation, in fact, the act itself, it means a mediation conducted under the aegis of mediation service providers. Now, this service provider, again, the act says, so 4 categories. It talks about what we are all normally introduced to: authority constituted in the Legal Service Authority Act, then court annexed mediation. That's how many people understand and know mediation in the first place. And body or an organization which is under the act, which will be responsible for the conduct of mediation, and any other body notified by the central government. Now, with reference to the act itself, says again that authority constituted in a legal service authority and court annexed mediation, they're normally the same. Court annexed mediation invariably come under the legal service authority. That's what manages it. And that is authority will be considering that. And body notified by the government, they'll all be immediately understood as service providers. But as far as body or an organization that provides for conduct of mediation, the Act says that it has to be one recognized by the Mediation Council. The Mediation Council has not been set up yet. So I would understand that any of our bodies, such as, say, for instance, Presolv360, which is empaneled with the High Court, with the Legal Service Authority, they will all come within the expression service providers. And in course of time, I'm sure with the Mediation Council, if it is in place, we'll all required to get recognized, so that our ability to accredit mediators and all other activities get to be recognized. You will notice, you asked me what would enhance the experience of the users of mediation. The flexibility on issues of logistics, perhaps, when you're talking in the context of online mediation, which can provide immediate connectivity from wherever you are, from whichever part of the world you are, and without having to subject yourself to long hours of travel, or positioning oneself in the comfort of home or office where you'll be able to work from. And that will all feature in online mediation. And again, an appropriate structure, an infrastructure which is built by the service provider, or what can enable communication seamlessly, will also be an additional feature which will bring comfort. And the critical issue in all this will be one of confidentiality. That's, I will recognize, to be the most crucial thing when we talk about mediation, and in the context particularly of online mediation. In any mediation, confidentiality is important, but in online mediation, I'm more concerned. Just as we begin, you say the recording is in progress. Then you have under the Act, recording is not possible. It shall not be done when we're talking about, therefore, mediation. If a trained mediator understands and helps the parties negotiate freely and without any inhibition to carry difficult conversations, and supplement online meetings with email or even phone calls to ventilate suggestions back and forth, such as refinements in the conversation between parties, you would have made an enduring impact on parties of how easy it is, and that there is a mediator who is able to help them navigate all these conversations so effortlessly. What do we understand by success in all this? Jawad would say, I've heard him speaking in many places, there is nothing like a failure in mediation. The very fact that you participate in mediation is a success. So that you get to be properly evaluated in your own rights and obligations during the discussions of what the mediator helps you understand. is an important thing, is an incredible feature in about the way we conduct conversations through the mediator. We understand our position, the parties understand position. Therefore, that is a success in itself. But then let us get to the success in the way we conventionally understand, that we are able to secure a settlement, a final end result which addresses all issues that have given rise to the conflict in the first place. There, I would think the most important thing, what should resonate as success for parties, is the ability to carry the whole thing in a confidential manner. What do you think gives itself enormously as an important olive branch for persons who participate in mediation? In court affairs and court proceedings, the documents can become immediately public documents the moment the documents are marked. Pleadings are public documents where anyone can obtain a copy and take it. Now, what makes it possible, except in certain types of offenses and sexual offenses and things where we have in-camera proceedings or matrimonial proceedings, everything else is open. And when you are providing for a process which is completely confidential, I think that is, if parties also realize how it is all being done, a kind-hearted person of the service provider always backs up the pre and post mediation session, where all the anxieties of parties can be absorbed. And if you have a friendly section in the mediation providers who can absorb that the anxiety from parties, that is probably the best feeling to have. In fact, I had myself the benefit of going through a mediation session where one party was connecting from Taiwan. It happened through your platform. I should be happy to announce that to you and to others. One was connecting from Taiwan, another from Delhi. And there was a contract for supply of some material which is banned for export during COVID because it was considered to be an essential good which could not be supplied. And therefore, the contract could not be carried out because what could be exported could not be exported by virtue of a government order. And the council were supported from one council from Delhi, another council from Mumbai. This was a pre-litigation settlement which was getting to be filed before the Bombay High Court if it was not resolved in conflict. Believe me, you know that probably to persons, other persons. It ended in 2 months flat. We concluded the proceeding, had a settlement going and filed in before the Legal Service Authority and got registered with the Legal Service Authority and by the Bombay High Court. I can't believe that in any other situation, anything like this could ever happen. That you have a party from Taiwan filing a case here and securing a decree and realizing the money in 2 months' time. No way, you can't joke. You can't even secure a small causes claim conducted and results secured in that kind of a time at God's speed. So, and I knew at the time the kind of communications which were happening, the ease of communications, how now with great technology, with large language models of what you have, translation, simultaneous translation also would become possible. And therefore, online dispute resolution opens up a whole new kind of a vista. It provides to people solutions in ways which you can't believe can ever happen. So that is so much a responsibility of what you have to keep confidential information and make possible communications in ways which are unbelievably fast and very efficient. So that I would think is all that you can be talking about when you're talking about the role of the service providers, the success of how the parties will surely obtain by the very fact of that participation. So that is my beginning thought on the topic which you're opening with.
Thank you, sir. I think you very beautifully bridge the gap of theory, what the Act says, and practically what really happens. And you did speak about confidentiality, which of course we'll be talking in a little more detail going forward. And very beautifully, you said that participation itself is success. I think that perception and that view really is a mindset change that is required in many of us practitioners as well. In fact, in our experience too, in the mediation matters referred by the courts, we have seen a success rate of over 80%. due to the efforts, of course, of the mediators and also owing to the proceedings being conducted online and the other benefits that technology brings to the process. And that leads us really to the broader policy framework, the thoughts on the broader policy framework. And I would like to direct the next question to Chitra ma'am. How does the Mediation Act align with the government's broader policy objectives on digital governance and access to justice? And what policy interventions may be imperative for the seamless integration of online mediation with the existing legal infrastructure?
Thank you, Bhavin and Presolv, and good evening to everyone. I think the first sort of meeting of the objective is the fact that there is a law dedicated to mediation. You don't have mediation as an aid to other policies and other laws, and we have a lot of mediation there. But this is a law that is of and only about mediation, and that itself is a huge thrust, a huge push. It's standing behind by the government of the mediation process as a worthwhile and an important process to resolve conflicts, and an important way of access to justice. You don't depend on anyone else. You depend on yourself to resolve this dispute. And once you've done that, we are here behind you, right? So that's a phenomenal and a big sort of push that the law gives. The second is the fact that the focus is, as Justice Kannan was saying, on institutional mediation. What this does is to tell users of mediation that there are these institutions that will be set up, mediation service providers like yourselves, Presolv. These are recognized by the Act. They will be all around you, hopefully. They are there, they're visible, they're credible, because you're going to have trained mediators there, norms, ethics, all in place. You have this law and they're accessible, right? So it's not, talking about mediation and then just leaving it there. There is capacity and resource building. There's infrastructure that is going to be around us of people with mediation. So visibility, credibility, access, that's the second. The third is the safeguards that the law provides for parties in mediation. And Justice Kannan spoke about confidentiality, and there is a lot of attention, a lot of section space provided to secure volition, confidentiality. So, parties' rights are safeguarded, and this is important, particularly when you consider the next point on the importance of the Act, which is that a settlement agreement will be enforced as if it were a decree of court, right? So this also then gives users who are considering mediation a great deal of comfort, because if they were to settle, then the settlement agreement will be enforced as if it were a decree of court. And that's a huge amount of certainty, a huge amount of push to the mediation process. It acknowledges, if there was any doubt anymore, that online mediation is mediation. So, this is, really the implementation of the government's, proposals on access to justice and, digital governance. On what needs to be done to are there any gaps between online mediation today and your question to, ask this? Very little, I think, but I'd like to identify maybe a few. The first is that, and this is, I think, also a plus. Guess who's already there as mediation service providers in the country? ODR institutions. They're already first movers. And I suppose what ODR service providers will need to do, I think they've done a lot of groundwork already. You've done work on conflict of interest. You've done work on, on processes. You've done work on getting panels in place of mediators. What you would need to do is probably evaluate what you have in place already with the policy and with the rules that are expected to come, because there is a lot, think that's going to be in the rules and in the regulations, and that alignment is something that I suppose will need to be done. So the mediators on the panel of the ODR institutions will need to be trained, in the manner contemplated by the Act and by the rules. I think there are some ODR regulations that are in place already for instance, the Ombudsperson regulations, the SEBI ODR regulations, which I think will need to be reevaluated to sort of meet with what the law expects of a mediator. To give an instance, the SEBI ODR regulations that were recently introduced speaks about a conciliator who will advise parties. It speaks about a conciliator who will ascertain what is the value in dispute. And the language is a little unclear, but I understand it to mean that the conciliator will also come to a finding on what is, the claim that's payable to the investor. And this, I think, will need to be realigned with what the law contemplates as a role for the mediator, right? None of these, certainly. Evaluative, I suppose, if parties want it, and, with safeguards in place for that. And as I mentioned earlier, the importance of processual safeguards in ODR institutions regulations, I think, will need to be firmed up to take into account the rights of parties, because at the end of it, this is going to be an enforceable decree, challengeable on very few grounds, which then means that a court that is looking at a challenge has very little to do, even if it finds that there is something, the problem, because this is a decree. One concern that I have is of legislation that came out along with this legislation this year, which is the Digital Personal Data Protection Bill Act, which talks about the overriding sort of tenor of that law is that information, if the government requires it, will need to be given to them. My anxiety is about how this would interact with the important sort of value of mediation, which is confidentiality. So that's something that worries me, and that I'm hoping there will be something sorted out, because if people know that what they're discussing in the mediation, what they've shared in the mediation is something that can be pulled up by the government, I think that can cause some sort of them to reconsider if they want to use this process online, not otherwise. So these were some of the concerns, the gaps that I think, but I think of all persons in this country, ODR institutions are best prepared to, flow along, hit the ground running, and speed the way. Thank you.
Thank you, ma'am. I think thank you for always being so encouraging. Undoubtedly, I think the explicit mention of online mediation always helps. I remember when we first started working, there was no category like legal technology. And 6-7 years now, and you see legal technology being, considered as a very budding, concept. And of course, online dispute resolution is a major aspect of legal technology, and explicit mentions of things like online mediation definitely does help in legitimizing and lending credibility to what we are doing. You also spoke about the Digital Protection Act, Data Protection Act, and of course, we have an act in place. We need to learn. We need to constantly evolve, because there will be things that we wouldn't have considered while the act was being drafted, and now that it has become law. But as ODR institutions, and this we've seen across in the industry, we've already started working on how to comply, how to ensure that insofar as it affects parties' rights when it comes to the data privacy aspects for individual parties, those things are taken care of, so that just because of doing it online, nobody is put to a disadvantage. In fact, recently in a couple of policy discussions undertaken by the government, in which Presolv was also a part, one by the DOCA for mediation in cross-border e-commerce disputes, and another by the MSME Ministry regarding solving for delayed payments. We have seen online mediation being weaved in as an important step to resolve such disputes. So that is also very encouraging that all the different facets, all the different stakeholders are actually coming together and pushing for online dispute resolution, whether it may be online mediation, negotiation, or arbitration. I would now like to ask Jawad sir that the Act contemplates a set of ethical guidelines and quality control measures for mediation services. So could you elaborate on how the Act ensures accountability of mediation service providers and individual mediators?
Sorry, I was muted. I didn't realize that. Thank you, Bhavan. It was quite enriching listening to both Justice Kannan and Chitra. See, every profession needs to have an underlying ethical basis, right? Because there is an element of trust that's involved in any profession. So from that perspective, let's see what, first of all, mediator ethics are, what they should be, what should be the guidelines. The first and foremost is, of course, neutrality and impartiality. The mediator must remain impartial throughout the mediation process. Each party should be approached, and each issue should be approached without bias or preconceived notions. All participants should be treated equally. The second is, we have been talking a lot today about confidentiality. Mediators have to maintain strict confidentiality. They cannot disclose any information that is shared with them during the mediation process, unless, of course, it's required by the law, or when parties give explicit permission to disclose the confidential information. One of the things that the assurance of confidentiality promotes is a safe and secure environment for the open communication between the parties, because a lot of information sharing happens during mediation, which perhaps may not happen in a court case or in an arbitration. But in mediation, you come up with a lot of confidential information. The third important thing is voluntary participation, because mediators have to ensure that all parties participate voluntarily and they have the freedom to make their own decisions. So any kind of coercion or manipulation actually undermines the fairness and the integrity of the process. Mediators, the fourth thing is, mediators must act with integrity and honesty and conduct themselves in a manner that fosters trust and respect. They should provide accurate and unbiased information, avoid any kind of misleading or deceptive tactics that could actually compromise the mediation process. The fifth important point is competence of the mediator and continuous learning, because mediators should possess the necessary skills, the knowledge, the experience to effectively facilitate the mediation process itself. And for that, I think they should continue to enhance their professional confidence through continuous training, education, self-improvement. Like, for example, if you talk about online mediation, I was mentioning just before the start of the webinar that we are, those who were born before the 1980s are digital immigrants, whereas those who were born after 1980s are digital natives. So especially for mediators who were born before the 1980s, learning technology is an absolute essential thing to do. And though we struggle with it, we managed to cope with it somehow. Okay. Right now, we are coping with it. We are able to talk to you across this online forum. Another important point, which I would put it as the sixth point that is important, is self-awareness and self-reflection. Okay, mediators should be aware of their own biases, their own value systems, the emotions that they're going through, and they should be conscious of that first, and then try to set that aside during the mediation process. And they should continuously reflect on their own actions and seek the feedback from the parties to improve their effectiveness as mediators. Another important thing is clarifying the roles and the process. Mediators should establish clear expectations and guidelines. for the mediation process, and they should inform the parties about their role, because invariably what I'm sure my co-panelists would agree with me that many parties, when they come to the mediation, they think that we are going to be either advising them or we are going to be deciding the dispute for them. So there should be a clarity on what exactly the mediator's role is, and because this actually helps to manage the expectations of the parties, and it also ensures the transparency. So what happens when you adhere to these ethical professional ethics is that you create an environment of trust and respect and also fairness. Now let's see how the Act deals with these principles. Okay, the ethical principles that we were discussing here. Section 15 talks about the mediator should assist the parties in an independent, neutral, and impartial manner in their attempt to reach an amicable settlement of the dispute. The subsection 3 says that the mediator should all times be guided by the principles of objectivity and fairness, and protect the voluntariness, confidentiality, and self-determination of the parties. Self-determination, we have to emphasize on that, because it has to be a decision. The outcome of the mediation has to be the decision of the parties, and the standards for professional and ethical conduct as may be specified. So it has not yet been specified. So once the mediation council is constituted, perhaps these guidelines will be more elaborately set out. Section 16 talks about the mediator shall attempt to facilitate a voluntary resolution of the dispute by the parties and communicate the view of each party to the other to the extent agreed to by them. Because when you're having private sessions with each party, there might be some information that the parties would require you to keep it confidential. So that is not information that you're going to be sharing. Whatever you share is with the permission of the parties. So you help them to assist them. The objective is to basically assist them in identifying issues, advancing better understanding, clarifying priorities, exploring areas of settlement, and generating options in an attempt to resolve the dispute. Subsection 2 says that the parties shall be informed expressly by the mediator that he only facilitates. The use of he is not mine, it is the legislature's. So they should have used a more neutral, gender-neutral term. But for some reason, our legislature is used to using the masculine gender there. So facilitates in arriving at a decision to resolve a dispute, and that he shall not impose any settlement nor give any assurance that the mediation may result in a settlement. Because it's entirely for the parties to decide. And as Justice Kannan also said, I keep repeating this very often, that there's no mediation that is a failed mediation. Because you set the parties on a path of rethinking, taking a re-look at their perspectives, about rethinking their whole approach to the conflict, and what is the best way to move forward. At that time, they may not be ready for a settlement, but it gradually happens because they are now in the process of thinking in a different way. So you have initiated that thinking in their mind. 17 says that the mediator shall not act as an arbitrator or as a representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute that is subject matter of the mediation proceedings, or be presented by parties as a witness in any arbitral or judicial proceedings. 22 now talks about, subject to other provisions of the Act, the mediator, mediation service provider, the parties and participants should keep confidential all the following matters relating to the mediation proceedings, namely, all those details are given: acknowledgements, opinions, suggestions, promises, proposals, apologies, acceptance or willingness to accept proposals, documents prepared. So we always make this very clear, even before the Act itself. We used to make it clear in our opening statement that it is a without prejudice process. So what you mean by without prejudice, to those who are not familiar with legal jargon, is that whatever you do in a mediation, it's not going to affect you in any way. If the mediation fails, you're back to square one. Nothing that happens in the mediation can affect you. So the Act simply reiterates that position. Now, these are the prescriptions under the Act. Now, how the Act proposes to implement these ethical standards, we'll have to wait for the mediation council to be formed, and what kind of disciplinary authority is going to be constituted, how any misconduct on the part of the mediators is going to be dealt with. These are all things that we need to wait for the council to be formed and the regulations to be framed.
Thank you, Jawad sir. I believe that it's going to be the collective responsibility of all trainers, mediators, service providers to ensure integrity and trust into the process of mediation. Undoubtedly, the Act and the rules will specify what are the guidelines, but ultimately it will be on all the stakeholders to ensure its implementation. Sagar, my next question is for you. So far, mediation remained underutilized, especially for uncomplicated commercial disputes. That was definitely a low-hanging fruit where mediation could be utilized very effectively. In your view, how does the Mediation Act incentivize and streamline mediation for such commercial disputes?
Thank you, Bhavin. And I believe my learned, seasoned co-panelists have already covered majority of the the acts, the sections and everything. But yeah, this is a good question to cover up all the things of the act. So if you see that the Mediation Act, it being established, is a special thing in the first place, because if we already have an Arbitration and Conciliation Act, I believe conciliation has always been ignored by many people, and it's always been arbitration, arbitration, arbitration. Now that the Mediation Act has been enacted separately, I believe it will have some kind of special force, especially when when it contemplates saying that institutional mediations and institutional service providers should be given more preferences. So that is something that would what do you say, it would back the act a little more as compared to what we had in conciliation. And I believe the definition of mediation also covers conciliation in the Mediation Act. So there are proposed amendments to the Arbitration and Conciliation Act, saying that the conciliation part of the arbitration would be redundant, and whatever conciliation proceedings are referred in the Arbitration and Conciliation Act would now be part of the Mediation Act. So that is something will definitely help in in resolving all the commercial disputes. And see, the main and getting a statutory recognition for the act for mediation is something that is a very good move by the government, I would say, because it's often ignored by many parties, saying that okay, fine, mediation, we are not ready to come to the table, we are not ready to communicate with the other party. So when my co-panelists already said that participation is success, I think that would be a good having a Mediation Act in support to that would develop a keen interest in many disputants to at least give a try to settle their differences, because our courts are already clogged with a lot of matters, and it's not easy to get justice through court system, and at a you can say at a fast at a pace. I mean, it's very difficult to get justice very fast. So Mediation Act would cover all of the gaps which we have in the litigation platform. So that is something that I look at the act as. I mean, it will become like a support to the arbitration and the court system, because arbitrations also run for a long period or a long duration nowadays, because arbitration is also something, it's more or less like you're in a trial. You have to provide evidences, you have to do cross and all of that. So it takes a lot of time. Whereas in mediation, parties come face to face, and all the discussions are confidential. So I mean, whatever differences are there, if they are able to sort it, resolve it through a faster platform, I mean, that's wonderful, I would say. So, and yes, of course, ODR and online dispute resolution mechanisms are now I mean, due to COVID and all, we have a lot of luxury of getting our disputes resolved as compared to what earlier earlier situations were. Like, you have to physically be everywhere. Now with online support, you can be anywhere where, I mean, without being physically present at that particular city or whatever country. So that is something that is the act is bridging the gap quite well, I would say, in that respect.
Thank you, Sagar, for sharing the points. In fact, the next time we have a panel discussion, I hope we migrate to a situation where, instead of mediation supporting litigation and arbitration and litigation will actually support mediation. And therefore, mediation becomes the default mechanism to resolve disputes. But taking this point forward, Chitra ma'am, organizations like banks, NBFCs, and even businesses are increasingly looking to resolve recovery disputes through online mediation. While mediation is perceived as a soft legal approach, which helps them retain their customers, administering it online increases participation and makes it inexpensive. Technological solutions further eradicate geographical and language barriers. With the Mediation Act's recognition of online mediation and mediation service providers, how can these organizations better leverage the mediation process for resolving disputes?
Bhavin, I think the fact that for me the sort of the best leverage that is available with this act for online service providers is the fact that the outcome or the mediated settlement agreement is enforceable as a decree. I mean, I think nothing beats that. And knowing that at the end of this, this is not just a dispute closed, but in the event there is any lack of implementation, and in my mind, and I think in the mind of most mediators, it's very unlikely that anyone would not implement a settlement agreement that they have worked, that they have sort of drafted. But in the event that that doesn't happen, for someone who is wondering whether to get into this process, knowing that it is going to be enforced as if it were a decree of court is a huge sort of source of support. I am repeating myself, but I think this is worth repetition. The second is the fact that it's not ODR institutions as outliers in dispute resolution, but ODR institutions as a part of the larger sort of infrastructure of institutional mediation that is now being introduced. And I think these two factors give a great deal of sort of comfort and encouragement for banks and other sort of service providers. The efforts that you were speaking about by the Ministry of Consumer Affairs and by SEBI, which is like focused on protecting, making it easier for investors to be able to take their disputes and to resolve it, and knowing that these are persons who are geographically scattered. Consumer versus an online service provider or an online provider of goods, they're all geographically scattered. How do we make it easier for them? Right? And I think efforts are being made by the ministries concerned, efforts made by SEBI as well. And with the backing of this act, I think it's going to make it easier. I also believe that, and that's a point you made as well, that MSME disputes will be, the Facilitation Council now has online dispute resolution institutions that are there with their panel of mediators, making it easier for the micro and small enterprises to participate. They're the institutional design in the MSME Act looks at their vulnerability, looks at their inability to wait forever to get their money, looks at their ability or their appetite for costs in getting this money back. And for all of these, the Act, together with the ODR institution and the ODR mechanism, provides a very good way for them to explore mediation and see if they can resolve their disputes that way. So this visibility that the Act pushes for mediation, for institutions, I think is a great push. And that in itself, I think, should encourage the use of mediation and online mediation. I seem to be ending everything that I say with caution, with the point of worry. And I'm referring now to what Justice Kannan was speaking about, a dispute that was cross-border. And I'm hoping this is going to be answered in the rules, but I just want to flag it. And this is that for international mediations, you need the mediation to take place in India. How does online fit within this? Is it online in India because the service provider is here? Is it online because one of the parties is here? I'm not sure, but I do believe this is going to be answered in the regulations. But this means that online disputes, shareholder disputes, I think we need to this was a conversation I had with someone in Agami. We need to stop thinking of ODR institutions as institutions that will do high volume, small value cases. We can use online mediation for bigger cases where parties have the sophistication to be able to participate on the online medium effectively, right? Shareholder disputes, commercial disputes, international disputes. I mean, your spanning geography, your spanning time, your as Justice Kannan so well said it, you're covering all these hindrances and handicaps to have an effective dialogue in resolving disputes. And so I think we need to also look at ways in which, and I hope that will be addressed, ways in which ODR institutions are able to do larger disputes, larger commercial disputes, spending the hours that are needed. 2 months, I mean, it's remarkable. And that's possible with online mediation. So we should be looking at also these spaces where online mediation gets into and is able to resolve. And I think it's a huge support that online mediation can provide to parties like this who are distanced by geographies, by countries and jurisdictions. So I hope that will be cleared. And yeah, that is it. Thank you.
Thank you, ma'am. Undoubtedly, I think things like the nuances in cross-border mediations, those kinds of nuances will possibly and hopefully get cleared in the rules and in the fine print. But at least domestically, online mediation is becoming more desirable as a dispute resolution mechanism. And in fact, many of our enterprises where ODR has already been deployed are witnessing remarkable results, not only in terms of cost and time reduction and customer retention, but also in the overall experience of dispute resolution. So hopefully this translates into more inspiration for other enterprises, other businesses to actually pick up online mediation and at least try it out and see the benefits of what this mechanism brings. Justice Kannan, my next question is to you. The Mediation Act introduces an array of technological interfaces, which invariably raises questions about data protection and confidentiality, which we were talking about before. How does the Act address these aspects, particularly in the context of online mediation?
Yeah, you employ the expression technological interfaces. If you must be identifying where they are there in the Act, you talk about probably in the context, it comes in the context of online mediation only, where you talk about use of data in electronic form or computer networks, encrypted electronic mail service, secure chat rooms, conferencing by video and audio mode. All these things find expressed in online mediation. It's not as if in mediation in physical meetings, you don't encounter them, but then more and more reliance on this electronic data has become the norm now. And in this provision of what you find under Section 30, it makes reference to confidentiality in about 3 places in the same section. It talks about the conduct of online mediation. It should have the element of integrity of proceeding and confidentiality. There's one subsection. Yet another subsection which talks about it must ensure confidentiality of mediation. So you'll find, then it also talks about the written consent to be obtained before we start the things, what is therefore an important thing. I'm glad Chitra spoke about the Digital Data Personal Protection Act of 2023. It has come about just on 11/8/2023, when we have this act notified on 15th September. Is it September, October, 15th October? Is it September or October? That about just about a month time probably was earlier, was this act came about. And here in this act itself, when it talks about confidentiality, I would understand this confidentiality will extend to even revelation of a situation, whether the mediation was the outcome of mediation, whether successful or not, who was responsible. None of those informations can be revealed, which I think is very important. But it says to an extent where somebody does not participate at all, it could be an issue. Where in spite of a mediation agreement there, if a person does not participate, they could be considered for the matter of imposition of cost later. But otherwise, who is responsible for the mediation not being successful has no relevance at all. I was seeing that the issues of confidentiality of what this act talks about with enormous vigor. If we must be thinking of retaining data and information of what we gather confidentially, it can't be seen only through the prism of this act. You'll have to look at it from the point of view of what the Data Protection Act itself talks about. And I was seeing that PricewaterhouseCoopers have undertaken a study recently, and they have examined some 100-odd companies from all sectors, like insurance, like a bank and other institutions. And they noticed some of those things seemed extraordinary, because the Act employs some expressions such as where there is in matters of data protection, you talk about data fiduciary. Who is a data principal. In the context of Mediation Act, it should be the person who is actually dealing with information. And about how, even at the time of joining, what kind of consent would be necessary, what kind of notice would be necessary. The Act doesn't talk about that. But then the Data Privacy Act contains details about what you'll be mandated to do, such as issuance of notices, the consent of what you'll have to obtain from parties, how it has to be an informed consent where the person is informed about every detail. Why are you picking up any data? Whatever data which you're taking from them, even the personal data, what you have from the person at the time when you register for mediation in your portal, you need to be saying why you're taking that information. This the Mediation Act does not say, but to the extent to which confidentiality lends itself to the highest, the primacy in the Act, we need to recognize it through the Data Protection Act. And it contemplates a notice to be given, and they found the children's data, personal data, for instance, of what can be secured through a guardian. The Data Protection Act again talks about how serious it is. And in matters relating to matrimonial mediation, relating to custody, where you gather information about children, how you'll be carrying that information. These are all critical areas of examination for service providers. And it's also stated there, consent is not always accompanied by a notice stating why it is being captured. That's not sufficient, because this PwC's report points out to only 4% of organizations were even found to have a breach notification in place. where a data breach, what information that you gather, how does it, if it ever gets to be revealed, how will you protect, what kind of notification will have to be done? And then they also found that there is no segregation of information relating to children's information relating to age. So all those important factors they have flagged. They also say that a transparent privacy notice, which clearly outlines what data is collected, why it is collected, how it is used, and with whom it will be shared. All these are informations which you have to give now. So therefore, service providers have the additional task of what the Act wants you to do, confidentiality, how is it to be secured for them, will have to be looked through the other provisions. So I will not see only the Mediation Act provides for it, but then there is a Data Privacy Act which surely lends enough information for you for compliance. That I think is what is a new task, is a greater concern. And I'm not really talking about what are the deficits of the Data Protection Act itself. There are enough said and written. I'll leave that alone. But then you'll have to get through confidentiality issues in ways which are very different from how we normally recognized. And that is what we need to be concerned about and what we need to be surely addressing ourselves about.
Thank you so much, sir. Jawad, sir, the Act presents new opportunities to advance the use of mediation as the first choice to resolve disputes. As key stakeholders, how can legal departments, practicing and budding professionals and mediators better equip themselves to adapt to concepts like online mediation and the technological transformation that the landscape is currently experiencing?
See, Bhavan, first of all, we must stop calling mediation as an alternate dispute resolution mechanism or even an appropriate dispute resolution mechanism. In my view, it is the most appropriate dispute resolution mechanism. Okay, so therefore, calling it as ADR itself is wrong. That should be the mainstream dispute resolution mechanism that should be followed. That should be the port of first call. The moment you have a dispute, the first thing you should go do is go in for mediation. Only if that fails, then the alternate dispute resolution mechanisms like going to court or arbitration come. So those are the ADR methods that we should be calling as ADR methods and not mediation as an ADR method. Now, when you come to mediation, okay, there is see with online, because mediation is one of the one of the mechanisms that is most adaptable to technology, and it embraces technology like fish taking to water. I don't know whether that's an apt analogy that I'm drawing here, but whatever it is, technology is integral because see, COVID has shown us that, and we are today, we have got so used to it that online webinars, online mediations are just being taken for granted. I do because for example, I stay very far from the court. So I told the mediation center that, look, I cannot travel every day 50 kilometers up and down to the court to do my mediation. So I will only be able to do online mediations. And people are very happy doing online mediations. Okay. They are because it gives them the comfort and facility of sitting in their wherever they are and taking part in the mediation. It has its own challenges. Sometimes, when the need arises, when the situation really demands, we do meet the parties personally also, just to keep the process moving forward. Now, when it comes to, as a continuous education, what should we do? Now, today we are living in an era of updating and upgrading everything, right? Right from our devices to everything else, we are upgrading everything. So we need to keep upgrading our skills, and it goes without saying that with the kind of changes that technology is bringing, now suddenly I wake up one morning and see that there is something called ChatGPT, and I can get all the information I want in ChatGPT. And I read somewhere that AI is not going to replace humans, but AI is going to replace those humans who are not going to be able to use AI, who are not going to be learning how to use AI. So that is where the upgrade is absolutely essential. And that's absolutely a no-brainer that any profession for that matter, whether you're a doctor, you're a lawyer, whoever you might be, you're a teacher, you have to keep upgrading because there's more and more information coming up. We are living in an era where information is flowing around like I don't know. It's amazing. I mean, the kind of each day, the kind of new discoveries that are made, the new technologies that are coming in. Without that kind of upgrade, I don't think that we can really survive. So, especially in the field of mediation, because it involves so much of personal interactions with each other. Now, there's something called digital empathy. How many of us have heard of digital empathy? How do you build empathy on an online platform? Now, that is something that we need to learn, right? What are the techniques that you use? What kind of words you use? What kind of facial expressions you use? Because your body is not visible to anybody. It's only your face, maybe up to your shoulder level, like how you can see me today, right? Now, how do you build that connection with the parties? So that is something that you need to learn, correct? So how do you communicate across the digital divide? Now, this is something that there are training programs available that teach you how to do this. And there are books written, volumes of books written. I think recently I came across a book called by Erica somebody. There was one book, I'm not able to recollect the name immediately, but on digital, how the digital empathy can be established, how the digital connection can be made, how you communicate even over emails. Because the kind of punctuation marks that you use, the kind of emojis that you use express much more than what your words can express. Because today on the digital platform, in a WhatsApp, I can send you an offensive message and put a smiling emoji over there just to take the sting off my remark. So these are all things, I'm still trying to figure out which emoji is for what. So sometimes I take the help of my grandson. Like I said, you guys are the digital natives and we are the digital immigrants. We are trying to master the digital language. So, this is absolutely essential today because if we are going to really use mediation in the way it is supposed to be used as a mainstream dispute resolution process, technology is integral to that. And as Chitra and Justice Kannan also pointed out, when you're talking about cross-border mediations, when you're talking about interstate mediations, people sitting in different parts of the country, people sitting in different time zones. And this is where the digital platform is, time agnostic, it's space agnostic. So you can sit anywhere and do the mediations. And it's not just on a Zoom platform or on a video platform that you do. You can do mediations even via emails. You can do mediations via WhatsApp. So there are so many options that are available to you. So as technology advances, the upgrade of your own skills also is absolutely required. And without that, I don't think that we can really do justice to the profession that we claim to belong to.
Thank you, sir. I think the past hour has just flown by and I thoroughly enjoyed myself. I hope and I do believe that our audience did as well. I'll quickly pick up a couple of questions that have come. We won't be able to take all. I'm cognizant of time. But we've got one from Leila Olapalli, ma'am. Would you say that most mediations today are hybrid, physical and online? Hence, online mediation service provider and mediation service provider are unnecessary distinctions. Anybody who could take that question?
Yeah, I suppose so. But then it makes us understand what we are talking about. It is an experience from every mediator, perhaps, that it's all a hybrid. Why it is like that in court as well. But then court, we still say physical courts. The courts exist like that, where judges come and arrive and sit and do things. In mediation, when we talk about online mediation, we surely recognize the person, the service provider, as the key element of who lends that online service. So to that extent, we still keep that expression alive. It makes us understand how we are going to generally understand. By default, it is online, but by choice of persons, and some ways it gets to be hybrid. So that's how I would see that.
We have another question that are there any measures taken by the government to ensure a fast track procedure for enforcement of these kinds of settlement agreements that are an outcome of the mediation proceeding?
Shall I take this?
Sure, ma'am.
One of the ways in which fast-track enforcement of a settlement agreement is undertaken under this law is by saying that it's a decree, which means that if for instance, it had the status of an agreement, you would need to go to court and say, A, there is an agreement, B, these were the circumstances in which the agreement arose, there was a dispute, or there was an underlying commercial or other agreement or relationship, and there were disputes. This was the agreement we entered into. These are the terms of the agreement, the fact that mediation took place, all of this is something that you need to prove. And that can be quite prolonged. It beats really the purpose of having mediation if you're going to go back and, take all the trouble like you would. I mean, why mediate? You could just, go to court and get your dispute resolved. So this says it is a decree, which means that you go straight off the bat in saying this is the decree, enforce it, and then it's the execution proceedings that come where the court assists in getting you what you want to get under the settlement agreement. So that's one way. The second is, of course, under the Singapore Convention, which we unfortunately have not adopted. And there are a set of grounds if there is a cross-border or international and commercial dispute which is resolved through mediation. The Singapore Convention provides a set of about 7-8 grounds on which I can take if I have an international mediated settlement agreement with the person or in relation to property in another country, let us say the United States, and the counterparty in the United States is not implementing the settlement agreement, I can take the settlement agreement to the appropriate court in the United States, show them the settlement agreement. They will evaluate the settlement agreement on these grounds that are set out in the Singapore Convention. And if it passes these tests, they will enforce it. So, you're not sitting to prove, yes, there was a mediation, even to show that there is that a mediation took place. Very short rules are there for you to be able to prove that mediation did take place. So there are measures, there's a lot of effort being taken in order to enforce mediated settlement agreements. Our government has said that we will look at the Singapore Convention after seeing how it is implemented by other countries. Godspeed to that.
Thank you, ma'am. And I think one final question. If an agreement is signed by the parties during mediation, and this is in reference to a matter which is referred by a high court in an arbitration proceeding, can parties then refuse to abide by the terms, stating that there was undue influence or coercion?
Can I take the question?
Yes, sir, please.
See, the procedure that we normally follow in the court annex mediation program is, once the parties reach a settlement agreement before the mediator, that settlement agreement is forwarded to the court. Now, the court follows a procedure prescribed under the Civil Procedure Code, where the court calls both the parties, examines the parties to find out whether they have voluntarily signed the agreement, and then passes the decree in terms of the settlement that has been reached, which is called a compromise decree. Now, normally what we see is that parties don't recant from whatever they have agreed to, but there might be circumstances in which perhaps if the mediator has not taken all the stakeholders into account, or there is always the back office people who have to either approve or disapprove the settlement. And if they have not been consulted properly, like for example, if you take a matrimonial mediation, in India, families get married, not two individuals. So there are many people who call the shots. And if a settlement happens which goes against the wishes of somebody else, they may shoot it down later on. Or if the lawyers have not been involved, or the mediator has neglected the lawyer. Now, the lawyer may tell the parties that, look, this is a very stupid settlement that you have reached. It's not going to be helping you in any way. So go back on it. So don't agree to it. So in those circumstances, parties go to the court and they tell the court that, look, we are not, one of the parties may say that we don't accept this. And if they say that, the court normally would not record the settlement, it amounts to the failure of mediation. So that is how normally we function over here, because the court has to be satisfied that it is an agreement that has been reached voluntarily by the parties with their full consent, knowledge, and concurrence. It has been signed. Chitra, correct me if I'm wrong.
Thank you. So I think I'm going out on a limb. One final question to all the panelists. All of you all, Justice Kannan, Jawad sir, Chitra ma'am, Sagar, have been instrumental in the coming of age for mediation. Are there any insights, any inside scoop that we as a public are not privy to and you would like to share about the Mediation Act or anything around that?
I would like my co-panelists to go first because they are seniors.
Yeah, some information if you are asking of what is not there in the Act, of what we thought was the most difficult thing to sort out, whether conciliation must form part of mediation or not, where we literally split. And it turned out that it's so dealt with so in such a facile manner under the Act. Without so much of sweat. It just, it is used, mediation is used as an umbrella term, which will take into account the conciliation as well. So therefore, what came as, therefore, a big surprise was it was not really thought of. We thought that the mandatory mediation was an important step because that was what was in Italy, although the bar struck work and did the things when the European Commission wanted that to be brought as relevant for every state, every member state. And when Italy went through that, the bar struck work. We thought, again, here in India, like what Jawad is saying, any dispute ought to be a matter that is settled. Invariably, the experience for persons who are in litigation, who are in courts, are that a judge does not understand. I'm meaning no disrespect to judiciary. I've been on that side myself. But at all times, I was never able to dispatch both parties happily. In whatever best of effort I would have put into a case. So therefore, any dispute, the power to the parties to find out what is best for us should be only through mediation. So we thought mediation must be made compulsory in every situation. Compulsory at least to bring them to a table. There is no way you can compel a party because the element of voluntariness would make it seem an oxymoron if you are also going to be saying compulsory mediation. But it ought to be understood compulsory in the sense that you'll have to try that before you go elsewhere. That didn't happen. It was something which was a disappointment. That's not there in the Act or doesn't say that there was we had recommended a mandatory mediation. Laila was also there. So that was something which is a difference between how the Act has come about to how we originally envisaged when we had our closed-door meetings.
Along with mandatory mediation, what got thrown out, most unfortunately, is the provision for an agreement to mediate. So, if I had a dispute with X, I chose Presolv as the institution, and I say we will attempt mediation before we try anything else. That got thrown out very, very sadly. But I think I'm hoping they will put it back in. It seems to be inadvertent because you have an entire section talking about an agreement to mediate, and then nothing. So I'm hoping that will come back in. I don't know why that went out, because you have more and more judgments, courts looking at mediation for the process it is, that it's not just an agreement to agree, and therefore, why do you enforce an agreement to mediate? Courts are saying we will specifically make you perform your agreement because you agreed to do this. I'd like to think that we still have it under the Specific Relief Act, but apart from that, it will be very good if courts, like in Section 8 of the Arbitration and Conciliation Act, will make parties go through with their commitment to mediate when they're forming a commercial relationship or a legal relationship.
One redeeming feature is even if there is no mediated settlement, the courts can refer to mediation at any time, irrespective of whether there is a failure of mediation in the previous round. So that seems a redeeming feature, that it does not bar the court at any time to do whether or not there is a mediation agreement or not. That's some redeeming clause.
I think there's the one more redeeming provision that I see is that courts are not bound to refer matters only to the mediation center that is annexed to the court. They also give the parties the option of choosing an external mediation service provider. So depending on perhaps the domain expertise or maybe the quality of mediators that a service provider brings, parties can choose to go to a private mediation service provider or a private mediator. So that option is given under the Act. So that is another redeeming feature that I see. So if you permit me, we can just end with a small joke on mediation. Is that okay?
Of course, sir. Of course, sir.
So there was a very tough mediation that was going on between husband and wife. And in sheer exasperation, the husband tells that, okay, I'm giving her my penthouse, I'm giving her my Bentley, I'm giving her $1 million in alimony. What more does she want? And the mediator turns and looks at the wife. And the wife looks at the mediator and says, no. So the husband says, what else can I give you? So the mediator again turns to the wife, and the wife says, I want him to listen to me the way you listen to me. I think the joke fell flat.
Thank you. Thank you, sir. On that note, I think, it's been an absolutely wonderful panel discussion. And just like how mediation weaves together with meditation, today's engaging panel discussion has beautifully woven together the panelists' wisdom with the rich fabric of the law. It becomes clear that the Mediation Act of 2023 emerges as a beacon of progress, demonstrating the agility and inclusivity of our legal system. Delving into the Act, our panelists have shed light on its nuances, from online mediation to the role of mediation service providers, giving us a comprehensive understanding of its transformative impact on the dispute resolution landscape in India. In sum, our dialogue today, infused with curiosity and humor, has outlined a way to resolve disagreements as calmly as one would seek peace in meditation. We are thankful to our panelists for their profound insights and to our audience for their active engagement. As we go ahead, we carry with us the wisdom of today's discussion, ready to apply the Mediation Act's ideals into our legal practices and beyond, encouraging thoughtful and peaceful problem solving. Thank you to the superstars of the mediation movement, Chitra ma'am, Jawad sir, and Sagar, for this engaging discussion, and to our North Star, Justice Kannan, who has led by example and is also the reason where we are as Presolv360 today. I would be also amiss if I did not thank my colleagues, Vaibhavi and Khanak, for the immense hard work and coordination in making this discussion fruitful. A big thank you to the audience for joining in, and wish everyone a wonderful evening and a very happy Diwali.
Thank you so much. And thank you, Dr. Renuka, for, being an efficient, coping with our speed.
Thank you, everybody.
Thank you so much.
Thank you. We'll take leave.
Yes. Thank you.
Thank you. Thank you.
Bye.
Bye.